It is my distinct pleasure to present this educational program on appellate advocacy. It is our hope that this program will educate students, researchers, and lawyers as they prepare to appear before the appellate courts. This program would not be possible without the support of the College of William & Mary School of Law, our nation's first law school. We would also like to thank the Virginia Trial Lawyers Foundation and the Bruce Rasmussen Scholarship Endowment Fund for their generous support. Bruce would have been an enthusiastic supporter of our efforts to train lawyers to enhance their skills and better their craft. With that, it is my honor to present The Art of Appellate Advocacy, a conversation with the Virginia Supreme Court. The task of questioning the justices goes to Laura Heyman, an exceptional professor of law at the College of William & Mary. Before turning it over to Professor Heyman, I would like to introduce to you the justices of the Virginia Supreme Court. Seated in the center is the Chief Justice, Cynthia Kinzer. To her right is Justice Don Lemons, soon to become the Chief Justice of the Supreme Court of Virginia. And to his right is Justice Lee Millett. To the left of Chief Justice Kinzer is Justice Bernard Goodwyn. To his left, Justice Bill Mims. To his left, Justice CLEO Powell. Unfortunately, due to unforeseen circumstances, Justice Elizabeth McClanahan could not be with us today. We hope you enjoy this program. Thank you.
Many thanks to all of you for joining us this afternoon. I'm looking forward to what I think will be a great conversation on a number of topics. And I do hope it will be a conversation. So I will be addressing questions to some of you in particular. But if the spirit so moves you and there's something that you would like to say, please feel free to jump in at any point. But with that, let's start and with a conversation about the judiciary as an institution. And Chief Justice Kinzer, I was wondering if we could start with you on this. Some commentators say that judges should never be influenced by their life experience or their political leanings when they come to the bench to decide cases. And other commentators say that it's impossible not to do that, that judges come to the bench with a lifetime of experience, and that necessarily is brought to bear on any decision that someone might make. Where do you fall on that spectrum? How do you assess those issues?
I think that we are all products of our past experiences, our childhood, and the things that we have done and experienced throughout our lifetime. So to say that we come to the bench and can set all of that aside, no, I don't think that's true. I actually think I disagree with the statement that we can and should. But what I do think is that we need to come to the bench recognizing if we have any kind of biases or prejudices and be able to set those aside. In some respects, the same kind of thing that a juror is asked to do. But also I think that you cannot come to the bench with an agenda. You have to look at each case and decide each case based upon the law and the facts, and that you should never use your past experiences and your lifetime events to press forward an agenda to try to shape the law in a certain way or issues because of your ideology. So that you have to leave behind. But to say that we are not a product of our past experiences, I think is just not accurate. We are.
Right. Justice Millett, what's your view on this?
I agree completely with Chief Justice Kinzer. I would just add a couple of things. I think that it's a very important, and I don't think it's that hard to do, to set aside your political leanings. Mm-hmm. As the Chief Justice mentioned, your biases and prejudice that may be based upon political philosophy. Don't have much difficulty in setting those aside. What life experiences I have as far as being a lawyer and a trial judge, I think basically have helped shape me, and I think I have to use those. I was a trial lawyer for 16 years and a trial judge for almost 18 years, and I tried a lot of the kinds of cases and was involved in the kind of cases that are now heard by this court. So I think that those experiences certainly have shaped the way that I approach my job at this point in time. And I think that's important for members of a court to do that.
Well, so let's talk about that a little bit more. Justice Mims, I was wondering if I could get you to think about this question a little bit. Some critiques of the judiciary characterize courts in some occasions as legislating from the bench. And you've actually had experience in the state legislature, both in the House of Delegates and in the Senate here in Virginia. how do you assess that critique? What does it mean to you when people suggest that courts occasionally legislate from the bench?
Very few people would suggest that a Virginia court legislates from the bench. That happens often in the federal system, but our perspective on this particular court is that we are here to interpret the law, and we are frequently called upon to interpret Virginia statutes because of the fact that Virginia does not have legislative history in the same fashion that Congress has it. So every court week we have one or sometimes several cases where we have to determine what did the General Assembly intend. But our role is never to supersede or to overrule the Virginia General Assembly. We exist under statutory law.
So what is it about the court here in the Commonwealth that makes it different? You suggested that there's something about Virginia that makes it different with respect to this question.
We are well aware that we operate under law and tradition. The law is the Constitution of the United States, the Constitution of the Commonwealth of Virginia, and the statutes that the General Assembly passes. The tradition is 800 years of English common law and American common law. That is something that every single one of us is aware of those constraints.
Justice Lemons, do you have a view on this sort of critique that commentators often make?
Well, I think one of the dilemmas is defining what legislate means. I agree with Justice Mims that we all come to the issue with the idea that the legislature has certain prerogatives that are theirs. Similarly, we have certain areas of our expertise and our duties that are ours. And the question of what legislation means is often in the eyes and the mouth of the beholder. Someone told me one time is that whenever somebody doesn't really like a decision of our court, they will use the word legislate to describe it. But the dilemma is that you can't actually pass statutes that anticipate every set of circumstances that might be affected by it or controlled by it. And so often we are called to what I will call interpolate. We have to look at a statute, we have to determine what it clearly covers, what it by implication covers. We simply can't turn away the litigants and say, come back someday in the future when the legislature has actually decided this question. We have to decide it. And I don't think that any reasonable definition of legislate includes those kinds of cases, because that's part of our duty. It's part of what we do. It's our oath of office. But from time to time, there are courts, as Justice Mims has said, that have a much more active view of their role. And frankly, they tend to go beyond the boundaries that the legislature may have set in certain areas. And when they do, I think that's when they legislate. But as long as we're within the boundaries and we interpolate, what we're doing is what we're called upon to do. It's consistent with our oath.
So, thank you. So, Justice Powell, let me bring you into this conversation if I could. Justice Lemons has talked about the role of the courts, and Justice Mims did as well. And you are a member of the court who has served at all levels of the judiciary in Virginia. I was wondering if you could talk a little bit about what you see as the role of the court in our society.
I think the role is exactly as Bill and Don have described it. We are to interpret the laws. We obviously recognize that we don't write them, but sometimes when they are unclear, our interpretation of them to some may be viewed as writing. But we recognize that we interpret the law as the legislature has drafted it, and that has always been our role and will always be the role of the judiciary, not to exceed those bounds, but to certainly operate within those bounds to answer the questions that come before us.
So, Justice Millett, back to you. We're talking now a little bit about the line between interpreting and legislating, as some commentators use the term. How do you find that line? Is there an easy way to determine where the line is between the two?
I don't think so at all. I think you usually have to use everything you've ever been able to understand as either a lawyer or a judge to try to figure out where that line would be. I would think that what you try to do is keep in mind, again, what our role is. Our role is to resolve disputes, to resolve the matters that come before us, and as an appellate court, to give guidance to the lower courts and to give guidance to the litigants as to how we came to that decision. And I don't think that that's a legislating. I think it's a deciding the case.
So, Justice Goodwyn, let me ask you perhaps what may seem like a provocative question in light of what we've just heard about, I think, restraint of the courts. Do you think courts function as change agents or should function as change agents in our society?
I think that they do not, and I think that they should not. Our job as judges is primarily to act as umpires and referees. You know, we're calling the balls and strikes, and we're using the Constitution of the United States, the Constitution of Virginia, and the statutes that have been passed by the General Assembly and Congress. So in that role, I don't think we're agents for change. Sometimes it may seem like we're changing things, but what we're doing is making sure that the rules are applied fairly to everyone.
So a very famous umpire once said, balls and strikes ain't nothing till I call them, right?
That's exactly right.
So the court, in some respect, is playing a role in helping to shape what the law is.
No doubt about it, and that's what my colleagues were just explaining as to how we do that. That's certainly part of the process.
Okay. Let's talk a little bit about the court's engagement with the public. So some members of the public might have a very good sense of what the court does and what the court does in the regard that we've just been talking about. And some might have a misunderstanding of what the court does, which may lead to some of the comments that we've been discussing in the abstract. Justice Lemons, I'm wondering if you could talk a little bit about what aspects of the court's operations or what the court does do you wish perhaps the public knew more about?
I remember one time being approached by a woman that I have known for many, many years in a public place, and she said, "I want to lobby you on the such and such a case." It was a case that was pending on our docket and was receiving a lot of attention in the press. And I said, you can't lobby a judge. And she said, "Why not? You're a public official." And I think at the heart of some of the things that the public, just generally speaking, just does not understand, is that we have an entirely different role and an entirely different purpose as a public official than their elected public officials do. We don't get lobbied. And I think they tend to, on many occasions, interpret what we do in the same way that they interpret what the elected branches do. They interpret it politically. And I know that I speak for my colleagues when I say there are many things that I have encountered as a judge that had I been in the legislature, I would not have crafted it in the manner in which they have done, and I wouldn't have supported it. But it's not my role to do that sort of policy. As long as it's constitutional, it's their role, the legislature's role, to do that sort of thing. The public doesn't understand that, most of the public. And when they see a decision that we make, they're more often than not going to interpret it through political lenses. That's not how we do our job. I would say one other thing about that is that an appellate court generally has matters before it that come in two categories. One is error correction, and the other is what we would call law development. Most of our cases are error correction cases. And as such, they don't involve the kinds of things that you've been asking about. Is this legislation? Are you beyond the boundaries? Generally speaking, most of our cases involve boundaries that are fairly well set. The question is, were they followed in the court below? And those are error correcting cases. It's only in what we would call the law development cases that you get the kind of issues that you've been asking about.
But even in some error-correcting cases, it's a question of interpretation. Does this term mean X or Y?
Well, there may be. When we have cases like, for example, sufficiency of the evidence cases, it's rarely that. Those kinds of cases, we're reviewing the record and determining whether a particular party bore their burden. And if we decide that they didn't, we say so. And there's nothing controversial, I think, about that. There's nothing law development about that. It's simply error correcting. And a lot of our cases fall into that category.
So Chief Justice Kinzer, I don't know if you share Justice Lemon's view completely on that issue of the public perception of the court, but if you do, is there something that can be done about it? Are there ways in which the public can better understand the operation of the court?
Well, I agree and share his views, but I would add to it that I think, and this is something I've come to learn very acutely as Chief Justice, is that the public really does not understand our system of government. I actually think we have missed a whole generation of people through civics education. I applaud Justice O'Connor and her iCivics program. That's wonderful, because the judiciary doesn't have an advocate. One legislator told me that he doesn't have people calling him about the judiciary. His phone calls are about potholes. So I wish people were calling members of the General Assembly about the court, the inadequate funding, the lack of staffing, as often as they were calling them about potholes. So I really wish the public understood better that we're three separate independent branches, and that at the end of the day, it is the judiciary that preserves the rule of law, and that at the end of the day, it is the judiciary who protects our lives, liberty, and property. We are the ones who have the authority to say a statute is unconstitutional. It infringes one of your rights guaranteed to you under the Constitution. And I don't think people realize that and appreciate it. So I would like to see more education of the public so that they become advocates. And I've become convinced that it has to happen on a grassroots level. You know, I go to the General Assembly and ask for funding and judicial vacancies to be filled, but I need people going to them, the mom and pop who runs the store and can't get their case heard. We need people like that going to the General Assembly and saying, the courts matter to me. There was a quote from, I think, Justice Kennedy, who said that courts are as important as schools and bridges, and I agree. But I'm not sure that members of the General Assembly do or that the public does, but they need to. So that's what I've found very troubling as Chief Justice.
So we need to send you out on speaking tours, or what is that?
I think I've been on a few,
Yes.
probably. But we're limited in what we can say and do. That's why I think we need help from just the average person, not just, yes, from the lawyers, but from the non-lawyers too, and that we need to re-educate the people. I think Abraham Lincoln said, if you educate the children, you don't have to educate the adults. But right now I think we need to educate the adults and the children about our system of government. And they need to understand too that we have a state system of courts and a federal system, and the differences between them. Because I've had people come up to me and say, well, I'm going to take that case to the U.S. Supreme Court. And I'm thinking, no, you're not. It doesn't involve a federal issue or a constitutional issue of the U.S. Constitution. So we are the final arbitrators about that. We have the final say about state law and our state constitution.
Well, that actually leads me to my next question. Justice Goodwyn, do you think, it sounds like for what the Chief Justice is saying, that the public in general doesn't have the same sort of appreciation for state constitutional law that it does for federal constitutional law. Do you think that's the case?
I don't think so. I think that the reality of the situation is that in most instances, because of the 14th Amendment, your rights under the state constitution are the same as your rights under the federal constitution. So as a practical matter, people don't make the distinction between the two. I don't think it's them not taking it seriously. I think it's them not realizing.
So is
the
there
rights are there.
Is there something that you think, to respond to the Chief Justice's, the issue she identified, something more that can be done to better educate the public about the role of the state Supreme Court in their lives?
I don't think that a whole lot can be done other than what the Chief Justice just mentioned. It's a matter of civics education. And certainly I think each one of us, probably we each speak regularly to different groups, and normally a part of that speech is going to be explaining what you do. So I guess a little at a time, people certainly are finding out, or they find out, but I don't think it's one of the most important things on their agenda to understand how the Virginia Supreme Court works.
Right.
So all we can do is educate the people we come into contact with.
Yeah, absolutely.
I think one thing too, I think unfortunately, at least in the press, in the national press, the federal courts get all the attention. State courts, whether it's in Virginia or elsewhere, do not get that much attention. But what people don't realize is that 95% of all cases in this country are filed in state court. And so the state courts are the ones who are truly impacting their lives.
Yes, we need a marketing company on this, it
Yes.
sounds like.
Well, I mean,
Oh, please.
I was going to add another point, and the Chief Justice touched on this before. I think most people really don't understand the difference between state court or federal court. I was at a church not too long ago when I was introduced, and when church was out, some little old lady made a beeline to me to give me the devil about the same-sex marriage issue that we were going to be deciding. I was like, I think you got the wrong person. It's not in our court. But she had no idea. She just heard I was on the Supreme Court and the issue was going to the Supreme Court, and she wanted me to hear what she had to say about it.
Justice Powell, you wanted to chime in.
Two things. I think here in Virginia, because most of the cases that impact the people of Virginia are heard in General District Court. And so most of them have no real appreciation or understanding or desire to understand what happens here at the Supreme Court level, because most of their issues will never reach us. And so to the extent that there is some education that needs to take place, it's probably there in the trenches at the General District Court level. One of the issues that is particularly interesting to me is the lack of knowledge in our high schools and middle schools. I think it goes back to what Chief Justice Kinzer said: if you teach the children, then you don't have to teach the adults. And so one of the programs that we engage in is a rule of law program where we try and interest the students in what the rule of law is about and try and teach them that the law impacts all of us, and to some extent, because I think in some communities there is a distrust of this body and everybody below us, every court below us, and to the extent that we can better educate, we can disabuse the notions of mistrust.
So,
On the subject of education, for many years I've actually been involved in an orientation program with new judges in the Commonwealth. And whenever I have general district and juvenile and domestic relations court judges, I always tell them, I said, you may not be the court of last resort, but you are the court of lasting impression, because that's where the citizens of the Commonwealth see the judiciary. A judge whom I know, who will remain anonymous, has a speech that he gives, and it's entitled, "Why I Hate Judge Judy." And the reason, it's a very entertaining speech, but he gives this speech because the knowledge of the judicial system for most people has come from sources that are at best misleading. And so, as my colleagues have said, there's an enormous amount of misunderstanding about the court system. Some of them is simply because they haven't seen anything, and some of it is because they've seen the wrong things.
This is the CSI effect that prosecutors often complain about with juries. So is there a way, do you think, to make the workings of the court even more transparent for the public?
Well, you know what's fascinating to me is I have people come up to me all the time and ask whether or not they can actually come to court and watch. And you would have thought that that was such a bedrock fundamental principle of democracy that you wouldn't get a question like that. Frankly, I think we do our best to keep our proceedings open to the public. They come in, they watch. Recently, the Chief Justice, with our blessing as a court, put the transcripts or the oral arguments of the court on the website, so everybody who wanted to hear what the lawyers had to say and what our questions were can hear them. Other than inviting them to our table to discuss the case, which we are not going to do, I'm not sure what else we could do. All of us are publicly involved. We're out talking to community groups. Every single person on this court is out in the community doing the best we can to explain the role of the judiciary. I'm quite sure that a lot of time is spent doing it. I'm not sure what else we could do.
Yeah, Justice Millett.
I had a thought about that. When I was a trial judge, I used to always talk to the jurors at the end of their term, and I was always impressed by how much they enjoyed and appreciated the experience. And I think they got a lot out of it and a lot of understanding of how the judicial system works. Now, of course, we're faced with declining jury trials in our court system. And there is always a limited number of people that can be involved as jurors, but that certainly seems to be a way for people to become participants and to understand the system. So that's one thought.
So let me ask perhaps a provocative question. Cameras in the courtroom? Is that a way to increase the public engagement, Justice Owens?
Well, we do have rules that allow that. At the moment, they are focused on the discretion of a trial judge. In the Supreme Court of Virginia, if you want to come in with a camera and you're in the media, you can come in. I mean, there's a way to request. We have cameras that have been set up. We've had arguments, at least snippets of arguments on the nightly news. So we actually have allowed cameras in our courtroom. Whether or not you have cameras at the trial level is another matter altogether, and there's a lot of other issues that have to be addressed about that. You know, Justice Millett was talking about the juries. The jury is the most democratic element in the least democratic branch. And so when you have a reduction in jury trials nationwide, which we do, all of a sudden you have fewer and fewer people actually participating in decision making in the judicial branch of government. And I've always been of the opinion that our citizens trust the things they participate in, and they lose trust in the things they don't participate in. And as a result, I think the declining jury trial and the lack of participation takes away all the things that Justice Millett was talking about that were valuable about educating the public. And it's something we need to be concerned about for the future.
Very interesting. Justice Mims, let me ask you, we've talked a lot about the kinds of cases that the court tends to hear, error correction versus law development. Let me focus on the law development part of the court's docket. Are there areas of the law that you think are underdeveloped here at the court, that you think the court has not had the opportunity to help interpret, help explain?
No. We receive petitions to hear more than 2,000 cases a year. And every single one of those is briefed as it comes into the building, before it comes into the building. And then it is analyzed by members of the court. And from that mass of 2,000 plus cases, we choose between 100 and 200 that we will hear fully on the merits with exceptional attorneys and often amicus briefs from other interested parties, which allows us to develop the law. To the extent that there's an area of the law which we do not address or rarely address, that would only be because it rarely comes before us.
So let's talk about then the process of judging. Let's move into the nuts and bolts since Justice Mims started on that. And Justice Millett, I was wondering if I could start with you. So the clerk's office dumps on your desk a whole stack of documents for a case. Talk to us about how you approach the case. How do you get your arms around it? Do you always start by reading the record first? Do you have a different approach for different kinds of cases? How do you start to get engaged with a case?
I'll be happy to answer that question, but maybe we should go back, because I disagree with his answer on the first question.
I would love to.
I thought you might want to hear a disagreement.
Please do.
Okay. Maybe this is the first time we've had a disagreement in the panel so far, but I disagree with Justice Mims. I think there are areas of the law that have been underdeveloped. And primarily it's an area of the law where there is some change. Let me give you two examples. One example is, I believe there's recently been an increase of the number of claims for defamation involved with employment cases. It's a way of looking at some old law. We've had defamation law for a long period of time, but now we're trying to apply it into a new area. in the area of employment. And I think employment lawyers are seeing that as a possible fruitful way to recover damages against employers. And so I believe we have not developed that enough. Now, I agree with Justice Mims, we will develop it as the cases come to us, but that's one of the areas where I think we have not been able to develop the law fully enough. Another example I'll give you is a case that we had a year or two ago. Happened to be an asbestos case. It happened to involve multiple sources of causation. And we came up with, actually I wrote the opinion, and we came up with an analysis that was slightly different than what had been used before, and that's another area of the law that needs to be developed. So there are areas, I think, that are underdeveloped in our case law.
And so when you say that those particular cases or areas are underdeveloped, do you mean that the opportunity didn't present itself in the cases that you've heard to develop the law, that the court wasn't ready at that point to take that extra step? What do you mean when you say underdeveloped?
I don't agree with your comment about the court being ready to take an extra step. We address the issues that are before us, and I think all of us have been frustrated by having a case in front of us that perhaps the assignment of error does not direct us to the area that we'd like to discuss, and therefore we feel constrained because we are limited by what the assignments of error are that the parties bring to us. So that's an example of an area where we're ready to talk about it, but the case is not in the right posture for us to do it, so we've got to wait for the next case. And in the example I gave you about the multiple causation, we talked about the particular case as much as we could, but there are certainly going to be other cases that are going to develop nuances or other ways of developing that law, and that's just going to have to come as the case law comes to us.
So let me invite anyone else to weigh in actually on that question. Are there other areas that?
I think there's a misunderstanding about how law development takes place in the courts versus the legislature. The legislature has an area of law that they want to address. They have the opportunity to address it soup to nuts if that's what they want to do. They have a holistic way of coming about a problem and addressing it. Courts are not like that, and they shouldn't be like that. It's like Justice Millett said. Justice, we spent so much time together.
We've said this for years, and he still can't get my name right.
He's Lee to me, and calling him Justice Millett is odd for me. But in any event, you hear this phrase, judicial restraint, and you ask yourself, well, what is judicial restraint? Well, I mean, it's like saying there's weather outside. Of course there's weather outside. What kind of weather do you think is outside? So there's a lot of different views as to what a judicial restraint is about. But at least mine, and I know some of my colleagues share, is that we have a minimalist approach to law development. As Justice Millett said, we only decide the issues that are actually presented to us. And when they are presented to us, most of us have a hierarchical way of deciding them. We don't address huge policy questions or constitutional questions if you can resolve it on a statutory issue. We don't address statutory questions if we can resolve it on the facts. And there's a hierarchical way of coming to a resolution of a problem that shows deference to a legislative body that's closer to people and to votes and to the population's view of things. So minimalism is a part of judicial restraint, and as Justice Millett said, we decide the matters that are before us mostly on the narrowest grounds possible. So in order to develop the law, it develops minimally. It's not that we don't get to it at some point in time, but it may take a while in a common law tradition for us to fully address the question like the legislature does.
Justice Mims, did you want to respond to either of those points?
I really don't, other than to say that as you listen to the three answers, we're not really saying anything that's too terribly different. We take the cases that come to us. Cases don't come to us until there is a dispute out there somewhere in the Commonwealth. We don't anticipate the disputes. When they come up to us, we don't go broader than what the dispute requires us to address. Consequently, I don't think there's anything that's underdeveloped.
So as a strategic matter then, does it behoove counsel to raise as many issues in the brief as they think there are possible assignments of error, to give the court perhaps an opportunity? Or Does the court actually respond negatively to having a brief that has too many issues in it? Justice Millett? What?
Personally, I think I respond negatively to it. I think if you've got some really good points, you should focus on the really good points rather than just sort of the shotgun approach and saying, I hope something sticks against the wall. Having said that, it is almost asking us to read our minds to say, well, how do I know what's going to be really important? I think if you really understand the law, if you've studied the law of your particular case and you know the facts of your case real well, you'll be able to divine, actually that's a poor choice of words, you'll be able to understand what are the real issues that need to be addressed.
Well, let's now turn to the issue of how you start engaging with a case. So let me return to the question that I posed
I avoided
earlier.
last time? Okay.
And then Chief Justice Kinzer, maybe I'll ask you to comment as well. So you get the stack of papers, the briefs and the record on your desk. How do you first dig in?
Interestingly, we have most of the cases that we deal with have already had a writ memo prepared by one of our chief staff attorneys or our own law clerks. And that writ memo has gone to the writ panel, the 3-justice panel, and the panel's decided that they're going to grant the writ on that. So I usually start there because it's sort of an overview of the case, and it's usually about 10, 12 pages, so it gets you a good overview of the case fairly quickly. I then look at the appellant's brief, and as I'm reading the appellant's brief, I will go through the record. Now, almost always I'll read the complaint, one of the first things I do, because almost always in every case, it's a civil case, the complaint is going to have some impact on the outcome of the case. But I do want to understand what the facts of the case are and the way the case is set up. And after I've read the appellant's brief and perused the record, then I'll read the appellee's brief and look at the record as part of that.
Chief Justice, the same approach or?
Not exactly.
No? What's your approach?
Oh, I read the appellant's brief, I read the appellee's brief, I read the reply brief, so that I fully understand what at least the parties think the issues are.
In that order?
In that order, yes. And then I would go to the record. Now, I'm not saying that, I never go to the record in the process of that. Maybe there's a letter opinion from the trial court, and after having read the appellant's brief, I really want to see what the trial court says, so I may stop and, go to the. So it depends on the case and what the issues are. The writ memo that Justice Millett referred to, I don't look at this point. I mean, I should say never, but that's a condensed version of the issues that were presented at the petition stage. And I only look at that if I've read all the briefs and I feel like they didn't tell me what this case is about. Maybe there's something in the writ memo that will help me. So I very seldom look at those once a case has been granted an appeal by the court. Don't say never, but it's certainly the last thing I do. And after I've done all of that, I would then turn to research that my law clerks have given me, or a bench memo that I might have asked them to do, or do my own research. But
anybody start with the appellee's brief? No? Everybody starts at the beginning and works their way through? Yeah. So at what point then, as you're reading, are you typically persuaded, or at least are you starting to form your thinking around the case? So maybe Justice Powell could ask you to start on this. So you start with the appellant's brief? And at what point in the brief do you start to think, okay, I know what this case is about, I'm starting to get this? Is it by the statement of facts?
Is it that I know what the case is about, or I know what the answer is? Which question?
Well, I'll leave it to you to answer that. Let's tend more towards the latter, actually. You're starting to form your view on the case.
It's an evolving process, actually. If I have a well-written appellant's brief, unfortunately, at the end of it, I've decided, yeah, you win. Then I pick up the appellee's brief and I read that, and at the end of that, I thought, oh no, they no longer win. The appellee wins. And then I get to the reply brief, and so it is an evolving process where I am considering the arguments that are made and very persuasive arguments from the two parties. Rarely after I've read everything do I have the answer. I usually wait until oral argument. Sometimes I'll talk with colleagues about it. Certainly the opinion conference has an impact on what the final decision, as far as I'm concerned, will be. And it may even go as far as the draft opinion that comes out before I can finally say I'm comfortable with this position. Usually it's very late in the process for me before I finally settle on a position.
Justice Goodwyn, let me ask you to address that as well, so that your thought process as you work through the case. So Justice Powell has talked about it being an evolving process. I'm sure that's the same for you as well. But do your thoughts continue to evolve through oral argument, through conference, or do you go into oral argument or into conference with a pretty clear sense of what you think?
I would say typically my process works exactly like Judge Powell's process, but in reality, what I've realized is depending on the subject area of the case, I might have more of an intuitive feel as to how it ought to go. If I know the body of law in a particular area and somebody's asking me to do something that seems completely contrary to the last 4 cases we decided, it's like, they've got a boulder they're pushing up a hill here. And I'm not saying I made up my mind one way or the other. I'm just saying that, all the alarms are going off that, if I've read the appellant's brief, I'm like,
Use a term of art, yes.
Yeah, exactly. That was a technical term.
Yes.
So that happens, and I find it happens the more background I have in the information in the particular subject area of the case. But even with that being said, I'm going to read everything, and my mind is completely open. And one of the things that kind of amazed me when I got to this court, because I read everything, and I think everybody's process is probably somewhat the same. You read the briefs, then I'm going to look at the research, typically a bench memo or something like that. And then a lot of times I'll have little questions. As I'm going through the briefs, I make notes like, why did they say that? Well, that don't make any sense. And then I go back and kind of answer my own questions to all these things that were left hanging out there. And then I pick up a dictaphone and I do something, I call it my bottom line, that my law clerks go. I just pick up the dictaphone and says, look, you know what the real deal on this case is? And then I just kind of dictate to myself how I think they're trying to tell me and characterize the case in the way that I believe it ought to be characterized given the facts and given what happened at trial and what the important concepts are that have to be dealt with and the questions that have to be dealt with. And that's what I'm going to take into the opinion conference with me as my colleagues talk. That's kind of like my touchstone for how I'm going to analyze things. And typically I try to come up with an answer at the end. But all of that being said, I was shocked to know how many times I have all of that and I get to oral argument and somebody says something like, I never thought of it that way. Wow, maybe I mischaracterized what the real issue is. And then you're all ears to try to fill in the blanks. So I think it is an evolving process, and I think we've all honestly been doing this long enough that you never say never. You're going to read everything and you want to understand the issues, and you're keeping an open enough mind so that when you hear something that doesn't fit into the concept or the construct you've created, you're like, wait a minute, I hadn't thought of that. Where does that fit? Does that make a difference? Whoa. And you see people at oral arguments start sitting up on the edge of their chair like, oh, and sometimes you see people's eyes get really big as they have a revelation during the process.
So now I have to ask what you do with that recording you make. Do you listen to it yourself at conference?
No, I have my secretary type it,
okay.
And it goes into a document I call the bottom line. So I've got, all the cases and everything, and then I've got Bernard's bottom line.
I call it Cynthia's stream of consciousness. Because I do the same thing. It's my stream of consciousness after I've gone through everything, and I dictate what I'm thinking at that point. It goes into my notebook for court week. My secretary types it up as well. And sometimes what I eventually do is contrary to what those notes say, but it helps me prepare for court week after I've read so many briefs.
So it sounds like, Chief Justice, that you likewise have been maybe persuaded at argument to think about something you hadn't thought about before. Are you persuaded ever by the writing, by the force of the argument in the brief? So you look at the issues and you think, perhaps approaching it with the same experience that Justice Goodwyn said, well, I know the law in this area, that seems like an uphill climb, and then you read the brief and the language, the strength of the argument maybe gets you to see it a different way?
Well, certainly the better the writing, the better the analysis in the brief, the more it helps me understand. And if you're helping me understand, then you're more likely to persuade me to that particular viewpoint. But it's not a moot court contest, so I'm not judging which brief or which oral argument is best. It doesn't mean that the person who wrote the best brief or presented the best oral argument is always going to win. That's frequently not the case. But it just, the better the oral argument, the better the brief, the more it helps me in coming to a decision and understanding the case and why I think a certain way.
Are amicus briefs ever helpful to you? Or how often are they helpful if they are?
Probably half the time. An amicus brief is good if it approaches it from a different viewpoint than that expressed by the appellant or appellee. But if the amicus brief is just repeating the arguments that have already been made by one side or the other, then it's not worth my time reading it. I mean, I read it, but at the end of the day, it hasn't helped me because it hasn't told me anything new. It needs to tell me something new that I haven't thought about or that the other parties haven't addressed.
So Justice Lemons, what's your view of amicus briefs?
You know, the word amicus means friend, and sometimes the party or the organization filing the brief is in fact your friend, and sometimes they're far more interested in their own underlying policy issues to be your friend. So sometimes amicus briefs really are not helpful to the specific issues that are before the court. They may very well be policy driven, whereas we're probably going to be driven by the narrow answering of individual assignments of error. Now, having said that, in the famous Grutter case in Michigan, when it got to the United States Supreme Court, it was an amicus brief that actually resolved the case. It was filed by the Joint Chiefs of Staff. And if you read the majority opinion in Grutter, you'll see that the amicus brief by the Joint Chiefs of Staff made it clear that they thought that nothing less than the security of the United States was necessary. It was necessary to have diversity in the officer corps in order to have chains of command that were going to be followed. And as a consequence, the amicus brief made the point that if you don't have diversity in professional education, you're not likely to have diversity in the United States military. If you read the opinion of the United States Supreme Court, you'll find an amicus brief made the difference. Now, sometimes that's the case here, but more often than not, it's not the case.
So it sounds like, along with what Chief Justice was saying, that in those cases where you're not simply engaging in error correction, but are helping to interpret the law, perhaps a perspective that you haven't heard from before that highlights the policy issues might be an important. Justice Millett, do you talk to me about your process again in going through the case? You talked a little bit about how you approach the case. At what point are you persuaded, or do you start to form your view? Do you form it as you're reading the briefs? Do you wait for oral argument?
I think I form it as I'm reading the briefs. Certainly, as I understand the case more and more, and I understand the parties' positions more and more, I start to feel more comfortable that I agree or disagree with whatever the appellant is arguing or whatever the appellee is arguing. But I don't make a final decision, I'm convinced, until I've heard everything. Certainly, even the oral argument. I've changed my mind a number of times after hearing the oral argument, and I think it's just the nature of the decision-making process.
So part of what is part of the record in each case is the opinion coming up from the lower court. Justice Lemons, let me ask you, do you assess the case in any particular way or in any particular posture depending on where the case is coming from?
I often avoid discovering which judge it came from in order to avoid that being an issue. It shouldn't be. The judge who decided the case below ought to be just a neutral factor. And we ought to decide the case based on what's been presented to us, irrespective of who made the call at the trial court.
Could it be helpful to you in some instances? So related to our earlier discussion about everyone brings some background, some life experience to the case. So if you knew, for example, that the judge below had extensive experience in law enforcement or other sorts of areas that might actually be helpful to framing the case, would that be information that would be interesting to you?
Well, it's interesting you'd frame it that way because it raises another issue that we have in appellate review on matters of sufficiency of the evidence, for example. I mean, our standard is plainly wrong or without evidence to support it. Now, does that mean that we would have made the same decision? No, it does not. What it means is, does the trial judge have before him or her sufficient evidence to support their decision? And I know I speak for my colleagues when I say that we have cases that come before us that we affirm that we would not have decided the same way in the court below. And I suspect that is a deference that's built into the system that we respect.
Does that deference change depending on the experience of the judge below or the characteristics of the judge below?
I think it is without regard to the experience of the judge below. I mean, if we look at a record and the record is sufficient to support the judgment is affirmed. And I don't think it necessarily is influenced by the fact that perhaps a judge was a prosecutor one time, or a judge was a public defender, or a judge was a plaintiff's lawyer, or a civil insurance defense lawyer. I just don't think that has much influence at all once it gets to us. But I do think that the trial court has a lot of leeway once it gets to us, no matter what.
Justice Goodwyn, do you pay attention to who the judge was below? Or?
No, I don't. I guess it goes back to my analogy about balls and strikes. I mean, if you Rod Carew, sometimes he was out at first, you know? I mean, so I'm just going to look at the facts of the particular case and decide whether or not a mistake was made. It really doesn't matter at all who made the call. And it goes back to, quite honestly, how narrowly we decide things. I mean, I'm just looking at the assignment of error, I'm looking at the record, and I'm trying to see, given the law, whether or not a mistake was made.
Good. So we spent some time talking about oral argument and how it affects or can affect the way in which you think about a case. So Justice Powell, I was wondering if you could talk a little bit about how you prepare for oral argument. Do you come in with a list of questions that you hope to ask? Do you sort of see how the conversation goes? Do you have particular questions or issues that you want to try to see get resolved, whether you're asking the question or one of your colleagues is? How do you start to think about oral argument when that day arrives?
Generally, I will come into oral argument with some questions that I want answered. I'll have them written down in my book and scripted out so that I can ask them intelligently before the cameras. And half the time I don't get to them, or the flow of the argument will turn me in an entirely different direction. And so a lot depends on how the argument is going, what questions my colleagues may be asking, something that they may say that I hadn't focused on in the brief from the litigants. And so I will come in with questions. I don't always get them answered, or they may become irrelevant depending on how the conversation is flowing.
Mm-hmm. And what kinds of questions are you typically looking for at that point, or trying to get answered?
The answer to the question.
Mm-hmm.
The answer to the case. Who wins, who loses.
But are they questions that the briefs didn't answer sufficiently? Are there typically questions that you think they didn't address?
They're generally questions that the brief raises. They may have an answer, but my question might be a what if. My question might be, the appellee argues X and you've argued Y, and I don't see that either answer is sufficient for my purposes. And so I may ask both litigants to answer the same question, but they're generally questions that is slightly different from the argument that was made.
Testing the boundaries of the argument,
Yes.
for example. You can think about the implications of what that argument might be. Justice Mims, let me ask you about oral argument. What do you see as the purpose of oral argument?
Every member of the court comes into oral argument with the desire to sharpen their thought process. So to some extent, oral argument allows us to do that. But it goes beyond that. And this is something that Justice Powell just touched upon. The litigants are there for one reason. They want to win their case. And they argue very effectively. We have multiple reasons. We want to decide their case fairly, and we are trying very hard to do so. But we also have to remember that the opinion that is written by one of the members of the court and then is agreed to by a majority of the court is going to be used in an innumerable number of cases in the future all throughout the Commonwealth. And so we have to make sure that the law that we are being asked to address, the issue we're being asked to address, can't be looked at only through the lens of those two advocates. So we will frequently use oral argument for purposes of asking hypothetical questions. I'll take their fact pattern and I'll change one fact and I'll ask both of the lawyers to address it with that one fact changed. Because I'm thinking not in terms only of what are we going to do 1 month from now. I'm thinking in terms of what is a trial judge going to do 10 years from now.
Have you ever been surprised by what a trial judge has done with an opinion 10 years from now?
I think we have each at one time or another been surprised at what trial judges have done with our opinions. And I think that it goes the opposite way too. I think trial judges at times are surprised with what we do with their cases. That's the nature of human nature. We are none of us are perfect, and so we all try to do the best we can.
So confession time. We've been talking about oral argument. Who has used a question at oral argument to actually talk to one of your colleagues, as opposed to who hasn't? Okay. All right. So Chief Justice, can you talk about that a little bit?
Oh, absolutely. If I'm unhappy with the way the tone of the questioning is going, I am not against, and have done frequently, interject a question to try to get the attention of my colleagues.
To change the tone of the conversation
Yes,
a little
or
bit.
to realize that perhaps the questioning is going in a direction that I don't agree with, and unfortunately the attorney is not able to turn it around, and so I want to get the whole issue on the table. I want my colleagues to think about this in a different way. They may not change their mind, but I want to make sure it's fully developed.
And Justice Goodwyn, you said you've done that too.
Oh, sure. And for exactly the same reason. Or sometimes you want to nail something down, especially if you know a colleague's like, well, I'm not sure about X or Y. It's like, you are saying X, right? You want to make sure that the person articulates it in a way that your colleagues will understand it. So sometimes you might ask them a question to give them the opportunity to do that. And of course, that could cut either way, because I think sometimes you feel like people misunderstand what somebody's saying, and because of that, they would support their position. When in actuality, if you really understand what this person's saying, you would never support that position. And if I have the opportunity in a question to bring that out, especially if I'm hearing questions from my colleagues that are kind of frightening me a little bit about where they're going with the case, yeah, you're going to ask the question. And quite honestly, through that question, it kind of signals to them your thought process as you go into this opinion conference.
Just sort of reframe a little bit.
Exactly,
Yeah.
reframe the issue.
Justice Millett, you had a view on
I
that?
actually do that too. I know that there are times when I may think that I've got a couple of votes from the way the questions are being asked, and I want to try to nail down my fourth vote, so I've got a majority, and I want to make sure that the person who's arguing has a chance to really explain what I think they may have said in the brief, and they may have not brought it out as clearly as I'd like them to have brought it out to the rest of the court. So it's actually almost a preview of the argument we're going to make later on at the opinion conference to get that kind of question out there.
Do you think counsel recognize that's what you're doing?
I hope so, and I can tell you sometimes they don't, because sometimes the rest of us will sit there and say, Counselor, that was a softball question. It really was not a hardball question, and so sometimes they don't understand it, but I think a lot of times they do.
So what sort of advice then would you give to attorneys at argument along those lines?
Listen, listen, listen. I think too often attorneys come into oral argument with a preconceived notion of what they want to tell us, and unfortunately sometimes it's just a restatement of what they've already put in their written briefs. That's not what we're looking for. I think the most important asset that a litigant can have, an oral argument before us, is to listen closely to what the questions are and to see where we're trying to go and answer the question, and then of course get back to your own argument if you fully answer our questions. But I don't think you can listen too closely.
Justice
There are
Clemens?
two things that every appellate lawyer ought to remember when they're standing at the podium. And one is they need to think like a judge, because they need to respond to us and our questions in a manner that is relating to an opinion, and more importantly, a majority opinion, as Justice Millett was talking about. As a result, they need to understand that this is their only opportunity to sit at our table. And if you're going to participate in the development of this opinion, this is your only opportunity to sit at the table. You better listen carefully to the other diners. And that's why this opinion, the questioning process is so important. I remember once on the Court of Appeals, this dynamic of the judges asking questions that really weren't to the lawyer, they were to the other judge at the other end of the bench, got so acute that this lawyer said at one point, if it'll help, I'll just sit down and let you all work this out. Now, I don't suggest doing that in the Court of Appeals or in our court, but having said it, what this lawyer was demonstrating is the lawyer really knew what was going on. And this lawyer knew that some of the questions that were being asked by one judge on one side may very well be either the majority or the minority view of this opinion, but they followed the questions and not necessarily their briefs or their planned oral argument. Every lawyer gives 3 oral arguments: the one they planned, the one they gave, and the one they wish they gave. And so you might as well come up there and be flexible and in a listening mode rather than a mode that says, I'm simply going to tell you everything I had planned to tell you. When you get there, you might better be saying things that the judges want to hear, because you need to think like a judge.
So along those lines, Justice Powell, when appellee gets up to give his or her oral argument, thinking like a judge, should he or she proceed with his or her own argument, or respond to the points or the questions that were just made during appellant's argument? What do you think is the right course of action then?
As I'm listening to my colleagues, and I was anticipating that question, was that on a sheet? I think probably first respond to the issues that we're obviously having difficulty with based on the questions that we ask the appellant. Certainly leaving time to address the issues that they came in wanting to tell us about, but I think they're going to be able to tell, or if they're listening, they should be able to tell what's bothering the various justices, what positions they need to develop in order to bring a justice over to their side or bring them away from the other side. And so I think probably the most effective approach would be to answer the questions that are being asked, even of the other side, in the way that best reflects their case.
Justice Mims, do you have a view on that?
I think particularly when the appellee is using their time, Justice Powell has hit the nail on the head. The very first thing the appellee needs to do is to respond to the questions or the dialogue between the court and the appellant's counsel, because it's clear those are the issues that we're grappling with, and you know, occasionally one of us will just simply short circuit the appellee entirely by saying, you know, address this issue first, and that's it really requires some dexterity to be a good appellee's attorney.
So what's a mistake that an advocate often makes, or maybe an inexperienced advocate, a first-time advocate?
The one that I always smile over is 2 of them, actually. One is when you don't recognize the friendly question. And Lee is right. Lee or Bernard will often say, that was a friendly question, counsel. And then second of all is when we do ask a hypothetical and the attorney will object and say, but that's not my case. We know that's not your case. That's why we asked it as a hypothetical, but we have to look beyond your case. But there are some light moments during oral argument. I hope that we are not viewed as a hot bench, quote, end quote, because we really are trying to do the best we can. And we have a lot of respect for the attorneys who appear in front of us, and the occasional pro se appellant or appellee who appear in front of us. We talk in terms of attorneys, but every now and then there will be a citizen who will come before us without counsel and will do a very good job. We all recall one young lady arguing about in-state versus out-of-state tuition, who referred to us as "you guys" instead of "your honors." And we actually, I think, all smiled over it because she was not trying to be impolite or disrespectful. That was simply her lexicon. Mm-hmm. And so it's an interesting process.
It's a wide variety of arguments, I think. Chief Justice, is there advice you would give to the new advocate, or maybe even the experienced advocate?
I think to all of them, I agree with Justice Millett, listen and be prepared. I don't care how eloquent you are, nothing takes the place for being prepared. If you're prepared, then you can bounce between issues. You can answer questions and go down a different path than perhaps the path that you had hoped you'd be able to follow in your argument. It's an intimidating situation. So, I would tell them, take a deep breath, and we're there not to trick you, but we're there to have a conversation with you and to better understand your case. This is your opportunity to talk to us about it. And so that would be my advice. But listen and be prepared.
So even the best prepared advocate will make the occasional mistake. So how does the court respond, Chief Justice, to those mistakes? So let me give you a hypothetical. An advocate, there's a question about whether an issue has been properly preserved for appeal, let's say. And the advocate misstates whether it has or hasn't. In fact, the advocate says, Your Honor, I believe actually we did not properly preserve that for appeal, when in fact it had been. Would the court's inclination be to accept that concession, which of course would then eliminate an issue in the case, or to recognize that it was an error at argument and consider the issue?
Well, you can't concede legal questions because we get to decide those. So only factual questions, perhaps, would we hold them to a factual concession. But if we recognize that they just were confused by what they were saying and made a mistake, because we've seen that, they misspoke what they meant, we don't hold them to that. We recognize that. And if it's a true concession, and if it's about an error preservation issue, we're going to go make up our own minds about that, because that, it's an interpretation of our rules given the facts of that case. So we don't hold them to things that are pure mistakes, no. Or at least I don't think we do.
Justice Lemons, do you try to help counsel a little bit in that regard, or?
Oh, I think all of us try to help counsel. I hope I'm not wrong about this, but I think we're a very user-friendly court. And I think there are concessions that are held against counsel that are made at the trial court and come up and are visible in the record. But as far as making a mistake in your oral argument before us, I think we're a pretty user-friendly place.
And I would also say between the 7 of us, typically somebody's going to say, did you really mean to say that? Mm-hmm. I mean, somebody's going to probably ask, and that's going to be one of those friendly questions. It's like, just want to make sure you didn't mean to say that you really don't have an appeal, did you?
Right. If they miss that, then they're really not paying attention.
Exactly,
right?
exactly.
Right. So, all right, so we've had oral argument, and now we start the sort of conference and decision process. So I was wondering if we could talk a little bit about the decision-making process at that point. And maybe, Chief Justice, I could start with you. Do you use your clerks to try to sort of think through some of the ideas? Do you exchange memos or emails with your colleagues? Do you really kind of try to thrash it out at conference to reach a decision? How does the eventual opinion result from the process?
I think it depends on the case. Mm-hmm. If it's a fairly straightforward, simple case with perhaps just 1 or 2 issues, then it probably has been thrashed out, at least for me, before I ever get to oral argument. That doesn't mean that in those cases that my mind might not be changed in some way. But for me, when the opinion writing comes, it's sitting down and writing it based on what I've heard from my colleagues at opinion conference and what my own thoughts are about it. Writing a majority opinion interesting experience, because for me personally, while I've got to reflect the views of at least 3 other people, if my name's on it, I'm not going to have anything in there that I don't agree with. And so there have been times when I've written an opinion that really was not the opinion that people probably thought I was going to write, because I got into it and realized this doesn't work, it doesn't write. And so I may send them a memo when I circulate it that explains why I've gone down a different path, and hope that at least 3 other people will agree with me after they've had time to think about it. But in terms of the interchange and exchange of information and memos between our colleagues, again, I think it depends on the case. If I'm troubled about an issue and want to talk with a person, or one of my colleagues, perhaps voice something at an opinion conference, and I want to explore that with them a little bit, I may call them, I may email them, or whatever. And then sometimes after an opinion is circulated, some of us may circulate a memo to maybe first to the author, or just call them, and then it might go to the whole court. It just depends.
So do you ever actually regroup? So if you have an opinion that didn't write, and so now you think, well, we have to change direction here a little bit to make this work. Will you have a second conference to talk about the issues?
Oh, we do. I mean, we have a conference in the afternoon after we've heard oral arguments. And then 5 weeks later, after we've had writ panels, we have what we call an opinion conference. And by then we have circulated those opinions to each other that we've written from the last court week. And we talk about them and get each other's comments. I'll never forget the first opinion conference that I attended. That evening there was a dinner, and I saw one of my colleagues, who was a senior justice at the time, and he said, well, did you have your baptism today? And I said, yes, I did indeed. So it's very interesting, the comments that you get from your colleagues, from you need a comma here or you don't need a comma there, to very substantive suggestions about the opinion and changes that should be made. So that's the primary regrouping time. And then after that, we would circulate these revised opinions to each other again. And then we actually talk about them again, via email and on Monday of court week.
So when you are surprised by a more substantive suggestion, where does that come from? Is it because you perhaps didn't have the sense you thought you had about your colleague's position on a case before that time? Or there's been a change of thinking about the case? What do you think causes that surprise when a comment comes in that you weren't expecting?
Oh, I don't think most of the comments that come in are probably things that I have been expecting. But sometimes they may have a suggestion, a way to improve upon how I've presented a particular issue. We welcome all of them. But I don't know that there are too many comments that come that I didn't have some sense of, perhaps from the discussions at opinion conference in the afternoons after we've heard the cases.
Justice Lemons, what about you? Do you feel as if by the time of the conference you know what your colleagues are thinking about a case?
The initial conference,
Yeah.
you're talking about,
Justice
right?
Goodwin is already
Yes.
nodding his head, but do you think, by
well,
the conference you know, or not, or you get surprised?
Most times the answer is yes. It's the ones where the answer is no that are most surprising, because from time to time you go around the table and you make your views known, and every once in a while you really are surprised by how a vote comes out. But underlying all of this is one principle that needs to be stated. The opinions of the court are the court's opinions. Now, an author has a challenge of writing an opinion that attracts a majority in order to have a court's opinion. And so even if we were not inclined to listen to other people, you have to be listening to other people in order to command a majority and to have an opinion that is the court's opinion. And the Chief Justice, I think, is absolutely right. There's nothing that more keenly focuses the mind than writing. And many times you go from a table where what you've been doing is talking about it, and then you go back to your chambers and you actually have to write it, and it's a different question altogether.
So what do you do when an opinion doesn't write?
Oh my goodness, I do exactly what all of my colleagues do. When I came on the court, and Chief Justice Kinzer now was on the court at the same time, there was a tradition of not talking amongst the justices until you got to this opinion conference that she referred to as the baptism. And I suspect the reason why it was referred to it that way is because you had no idea what your colleagues were going to say. Today, we don't operate that way. We feel free to pick up the telephone and call each other, send each other emails, and discuss things. So when we actually get to that second opinion conference, the first one is on the day of the argument, the second one was when a draft is out there, most of us have heard from our colleagues, and we have a pretty good idea where the pressure points are. It's a much better way to produce a majority, or for that matter, a dissent.
Absolutely. I mean, at this point, I've been on the court longer than anyone else here, which says something about my age, I guess. But I remember very well being told when I started on the court that you talk about the cases after you've heard oral argument in the morning, and you haven't talked to anybody about them before that. And once the opinion comes from your colleagues, you know, that what they've written, you don't offer any comment back to them about it until you come together again that fifth week I was talking about. And so you were often blindsided by very substantive questions, comments, and you're just like, you're struggling to remember what your thought process for why you wrote it that way, whereas if it comes earlier, you've had a chance to think about it. And I remember so well the first time that I dared to send a comment to one of my colleagues before the opinion conference, and that I had found a case that I thought would really help the opinion, and I wanted to offer it to him. And so I sent him an email and did not know whether I would incur his wrath or not, but he put it in the opinion. At opinion conference said, you know, Cynthia offered this to me and I think it was a good suggestion and I've incorporated it. And you could have knocked me over because I didn't know what the reaction was going to be. But it was good, and I think slowly that has changed, and I think it's a good change.
More collaborative
Yes.
process because of necessity. It's the opinion of the court, and so even though it's authored in most cases by a particular justice. Justice Goodwyn, you sort of nodded when we talked about maybe once in a while being surprised.
Being surprised, I guess I was thinking, first of all, it's important to understand that when we have an opinion conference after oral argument, every person on the court speaks to that case. So you know how everybody at that point in time anyway thinks the court ought to be resolved, how the case ought to be resolved. And if you're the person writing the opinion, you're writing the opinion, you've told them what you plan to put in it, and that's what should come back. So when the first time we go around the table, a lot of times I don't know what people are going to say. You might have a sense, but you don't. And sometimes people have, provocative, not the right word, but you know, the ball bounced at an odd angle. I mean, you know, from what I thought the way it was going to bounce when I hear from them. And really, you just can ask them questions as to, well, why do you think that way? Why do you think it ought to work that way? And a lot of times you're thinking to yourself, well, let's just see what the next person says. And you know, as you work your way around to see whether, you know, it's something that's like a little bit odd or whether you can kind of like miss the boat on what the issue is. And so, yeah, I mean, sometimes the eyebrows go up, but everybody's had a chance to give their input. And the second opinion conference is one where if you have substantive changes, typically it's going to be a bit of a surprise because the way we operate now is when I circulate my opinion, it's typically going to be at least a week before the opinion conference. And if somebody has a problem, they typically will at least say, you know what, I really have a substantive problem with what you've written, and let me tell you why. And so they're going to typically give you a little bit of a heads up, so it's not so much of the kind of ambush I think they did. I wasn't here back in those days when they did it that way, so I was blessed to have missed that. And I think what happens, honestly, is a lot of times we're going around the table and people agree. If you've got a very complex case with a lot of different issues, sometimes people think, oh yeah, I agree with that, but they didn't agree with the specifics of that. So when you actually put it down on paper, they're like, no, that's not what I meant. And it's kind of like, I said what I said, but I didn't mean it to be what you wrote. And you're saying, aren't they the same? They're like, no, it's not. It's not the same.
Right, it's very different when you put it on paper.
Exactly,
right?
exactly. And that's where the rub comes in at. And that second opinion conference, a lot of times there's, you know, a rewrite in order.
So in cases where there's a dissenting opinion, if you were writing the majority, Justice Goodwyn, do you talk to your dissenting colleague through the majority opinion? Do you engage with your dissenting colleague beforehand to try to figure out how each part of the opinion is going to speak to the other part of the opinion? How does that work?
I think it's a matter of personal style. You know, my style is just to pick up the phone and call you. I mean, it's like, what do you, you know, I don't understand. What don't you think is right about this opinion? Is there something I can do to massage it? Can we work it out? And a lot of times you talk through it, and every one of my colleagues are, you know, wonderful people to get along with. And at some point you realize perhaps we just disagree. I mean, okay, well, let's find out where the pinch point is, and sometimes you can smooth it over, and sometimes you can't. And if you can, it's like, okay, I understand you're gonna write a dissent. And typically the dissent is what I expected, given our discussion that we had as to what they disagreed with in the opinion, which, of course, I think they're wrong. so I don't, you know, agree with what they want to say.
So Justice Mims, when you are on the receiving end of this phone call, you're writing a dissent. What's your approach? How do you engage?
It's done on a case-specific basis because if, first of all, you have to decide, am I going to write a dissent? There are many times where I may have wanted an opinion to come out differently than it did, but I elect not to write a dissent for any number of reasons. If it's a case where I am dissenting on a particular issue and there is room for further discussion, then we will have a very substantive discussion about exactly where are you and why are you there and what cases support your view, in order to really to be like iron sharpening iron. And the dissent actually can make the majority opinion better. There are other times when one justice has very strong feelings and elects to write a dissent and is out there by themselves, and the other 6 justices respect the fact that there are such strong feelings. But it's pretty clear early on that there really is not room for further discussion, because it's you're seeing the world through different lenses. And there the majority opinion will often sub silento address the dissent, but rarely will it address it in an overt fashion. The one point that was made that I think really needs to be underscored is that we have a lot of respect for each other individually. We have a lot of respect for each other intellectually and jurisprudentially. And so we are able to dissent or concur without it appearing that that there is that a war has broken out in the conference room and that it's spilled over onto the printed page. Not every court has that level of trust and respect.
So you said something just now that I found very interesting. If I understood you correctly, that you don't always, in a majority opinion, feel as if you need to respond to the dissent, if I understood you correctly. And I'm curious about that. Why wouldn't that be the case?
It's actually pretty rare that you will see one of our opinions specifically say, the dissent has said this and here is why the court disagrees. We tend to address it in a more subtle fashion. Your analysis has been sharpened and has been changed, and you are answering one or more of the charges of the dissent, but without specifically saying so. I like that that particular rhetorical style, because it gets away from any hint at being personal. I don't think that it behooves a court to be going back and forth with the majority opinion said this, the dissent said that. No, the majority opinion said this and the dissent said that. that doesn't help the development of the law.
Justice Powell, maybe I could ask you to comment on this as well. So what do you see as sort of the value or the role of a dissenting opinion? And do you think there's more freedom for the justice who's authoring a dissenting opinion? Do you feel like the dissenting opinion should respond maybe more directly to the majority opinion? How do you approach that?
I think the dissenting opinion often will respond more directly to the majority opinion. You don't see that working in the reverse. And I think that's more a culture of the court and to some extent that degree of respect for the majority opinion. But you will often see the dissent responding, I think, to certain aspects of the majority opinion. And I think most often that's when the dissenter really has a strongly held belief that there is something analytically wrong with the majority opinion, and we want to get that view out there. I think sometimes it might, if I'm the dissenting writer, it may be writing for the development of the law. This is where the law is now, not necessarily telegraphing where it should go, but perhaps some instances of, yes, this is where we are, but perhaps this is where we should be. Personally, I sometimes will write for the benefit of the litigants who've brought their case all the way to this court, for that circuit court judge who had a differing view. If I feel strongly enough about their position, then I will write to not necessarily vindicate their position, but at least to say, you were heard. I think that comes from the fact that as a circuit court judge, I had a 7-0 reversal, and I thought certainly somebody on the court saw it my way. So a little nod to the circuit court judges out there that you weren't totally off in left field all by yourself. But I have to feel fairly strongly about it. I'm not just going to do that to appease the circuit court judge.
But you do need, it raises a wonderful point, you do need, when you're writing an opinion, whether it's dissenting or majority, to speak to a variety of audiences. You're speaking, as you said, to the litigants in the case, you're speaking to counsel, you're speaking to the lower court judge in a particular case on appeal, you're speaking to future trial court judges who are going to have to interpret. Maybe in a dissent you're helping to shape the law or suggest the direction of the law. So how do you address all of those audiences in one piece of writing? Do you have to choose which audience you're going to emphasize? Do you try to address all of those audiences?
I think I'm more addressing the issue, and the issue will then speak to the audience. I'm addressing the issue with which I disagree, not necessarily targeting an audience so much as targeting an issue.
Justice Lemons, can you speak about this from the side of the majority opinion? Because the same issues are there as well, that opinion is going to be read by a variety of different audiences and has to speak to all of those audiences. So how do you try to address that?
Well, let me start by making the observation that in Virginia, there's one group audience that should not be addressed, and that is some idea that we have constituents. Now, in states where judges are popularly elected, they have constituents, and you can see a stark difference in opinion writing in those states, because when they write opinions, they're often appealing to a constituent base that may or may not return them to the bench. We don't have that in Virginia, and I'm very grateful that we do not, because as Justice Powell says, without that, you can simply focus on the issues. In some of these other states where there's an election around the corner, I am quite sure, and I know for a fact because I've talked to them about it, that the way an opinion is drafted may very well have a whole lot to do with how quickly the ballot box is going to be opened. We don't have that problem. And so that's one group of people that we don't speak to. As far as the others, in many respects, we go back to whether this is a law correction, an error correction, or a law development case. If it's an error correction case, you're speaking to the parties, the trial judge or the intermediate court below, and you pretty much are limited to those audiences because there's not a bigger audience. In the law development cases, you may very well be speaking to future justices on this court. You may be speaking to the Court of Appeals. You may be speaking to the legislature. Take a look at this. Perhaps you ought to weigh in. So there are different audiences, but I do think it varies case by case.
So do you adjust your writing style depending on the audience you intend to address? Do you adjust your writing style depending on the type of case it is, or do you feel like you have a pretty consistent style?
Well, style is the word that I find interesting there. I think in terms of organization and things of that nature, most of our opinions look pretty much alike as far as organization is concerned. We've developed this not by some sort of agreed upon form, it's just been habit. We bring on the case and we summarize arguments and then we knock off the issues one after the other. I think Justice Mims has said it well. Our style has not been to be personally confrontative. And I think that style has carried over in many ways to other audiences. We're not confrontative with the Court of Appeals. We address issues. We're not confrontative with trial courts. We address issues. So if you talk about style, I think the style that we have is a style that has been very well described by my colleagues. We address the issues, it's not personal, and we decide cases in two categories, error correcting and law development, and you ought to be able to tell by looking at an opinion which category it's in.
Justice Millett, what do you think about that? Do you have, could someone look at a Justice Millett opinion and know that it was yours without your name on it?
I think so, probably.
Why, how so?
I try to be as clear as I can, and I think the primary audience that I'm writing for are the trial judges and the trial lawyers. And I remember from my time in both of those roles that you really don't have the time to look for nuances in a particular opinion. You really want to know what you're supposed to do when you have this kind of issue come before you. And I think that a style that makes it as clear as possible for the trial judges and trial lawyers is the best style to use, and that's what I try to do. And I think by doing that, hopefully the litigants in a particular case also understand where I'm coming from.
And so would you say that's the hallmark of your style? So what is it about your
so.
style that you said you think
if
somebody could recognize an opinion as yours?
If it's simple enough to understand, for me to understand, then it's probably a good opinion.
Okay.
There is an opinion out there, and I will not identify it, that was written by Justice Millett, but it was handed down by me. And I suggest that you'd have a hard time figuring out that he was the author.
Justice Goodwin, what do you think? Is there a Justice Goodwin style?
I don't think so. I like to think of my style as Spartan, sparse. It's kind of like the Dragnet style, you know, Joe Friday.
Just the facts?
Yep. Just tell it the way it is. Not a whole lot of flash. Just answer the question, which I think is kind of similar to what Lee was saying about the way he writes. I mean, I'm just trying to have something that's accessible, honestly, to everyone. I would hope one could pick it up, follow the logic in it, and see what the answer is.
So,
You can always tell my opinion if my name was never on it.
how so?
Because in the first paragraph, I give the litigants the answer.
So you don't bury the lead, it's right up front.
Now, in the first paragraph, which I usually write last, I try to, in as few words as possible, state what the at least primary issue or all the issues are, whatever, and say, and for these reasons, we're going to affirm, reverse, whatever it is, so that they can, in the first paragraph, know the bottom line without turning to the last page. And I think I'm the only person who does that, so that's a dead giveaway for me.
So the opinion issues, Chief Justice, have there been times where you would look back on an opinion that you've authored for the court and wish you'd phrased something differently?
Oh, absolutely. It happens when you see how either attorneys or a trial court has taken the opinion and interpreted it. And based upon the language that you use, perhaps they are interpreting in a way that you know was not what you intended. And so you think, wow, I could have said that more clearly. And it's not unusual at all to stop at the end of the day and realize you've spent an entire day trying to get one sentence or one paragraph the way you want it to make it clear. So yes, there are times when you've used words, had sentences that you regret, they come back to haunt you.
Does that influence how you approach the task going forward, or that's simply part of the game and it's going to happen every once in a while regardless?
It's part of the job we have, but I think because of that potential, at least it causes me to try to write as narrowly as possible and to not leave a lot of room for interpretation that may be not accurate because of language that I've used or said too much. So I think I try to write narrowly.
Does that ever enter your decision-making process when a party files a petition for rehearing?
Because I've written it narrowly?
Because the petition might cause you to look at the language that was used in the first opinion and think about its implications that hadn't.
That has happened, and there have been a few occasions I can recall in the past 17 years where someone might raise something in a petition for rehearing, and you look at the opinion and go, oops. And we've actually, not actually granted the petition for rehearing, but we've withdrawn the opinion and taken out a footnote. I remember an opinion where I took a footnote out because the petition for rehearing was like, oh yeah, I should not have included that, and I took it out. So that happens, sure.
Justice Millett, does that enter your thought process as well on occasion? Or?
I think it's sort of the law of unintended consequences. Sometimes your opinion will come out and people will interpret it differently than you thought. And to me, one of the best ways of avoiding that is the wisdom and experience of my colleagues, to be quite frank with you. A lot of judging has to do with experience. And so when we have people that have had more experience on the bench and they say, well, we had this come up 7 or 8 years ago, and in that case we said this, and you're saying this in this particular case, might cause a concern. And it really helps a lot, and it makes you feel a lot more confident about your opinion when you've had that feedback from your colleagues that you really might want to tweak that and make that a little more clear.
I suppose it also requires a certain level of humility not to be too wedded to your own first draft, I guess.
Yes, I think that's probably true, and I think all of us are pretty much like that. At least I hope we are, because it's not the writing that's so hard; it's the rewriting, right?
Exactly right. Exactly right.
There's a question that you'd hear at our table often, and it comes from each one of us to each one of us, and the question is that necessary to this opinion? Because that's the sort of thing that makes a minimalist out of you. Because you have the experience over time is, I wish I hadn't said that, and more importantly, it wasn't even necessary to the opinion. And after a while, we start asking each other those kinds of questions.
That seems one of the benefits, Chief Justice, of the more modern approach that you've described of more collaboration. It's more likely to catch those, I would think, catch those instances, whereas previously maybe those made their way to the final opinion without too much vetting. Yeah. So we've talked a lot about the court as an institution and about sort of the nuts and bolts of the decision-making process. I'd like to close with a few questions about your individual experiences on the court or your experiences as justices. Justice Lemons, maybe I can start with you. How would you describe your judicial philosophy? Or maybe another way of phrasing it is, how do you think your colleagues would describe it?
Well, hopefully they're pretty close to one another. Well, I suspect we will. I think that a judge should be restrained in how they resolve the matters that have been presented to them. And that requires you to be, in some respects, a minimalist. You don't decide questions that are not necessary. You decide only questions that are, and you do it as narrowly as possible. And you do it because you respect other branches of government. You do it because there are some issues that are better left to other branches of government. There are some issues that ought to be decided by the branch that's being elected by the people directly. So I think my colleagues would say that I am somewhat of a minimalist in the true common law tradition of incremental change in the law, modest writing, narrow writing. At least that's what I aspire to do.
Do you find that frustrating, the minimalist approach? You mentioned earlier as part of our discussion that there are some issues that simply aren't presented to the court, but that the court might welcome at some point hearing about, and that there are some issues that simply aren't for the court to decide, they're for the legislature, even though you personally might not have decided them the same way. So does that approach, do you ever find that sort of personally frustrating, that there are issues simply that aren't there for you to decide?
Well, there are some cases that I wish there were issues properly presented to us that we could reach. But you see, we're full circle now. Because if we're frustrated enough to go out and reach them, then we are legislating. We're beyond the boundaries of what has been properly presented to us. And as a result, we simply wait patiently and hope that in the future somebody will raise the question that many of us have been wanting to answer.
Justice Mims, do you share the judicial philosophy of minimalism? I think perhaps you do, based on your earlier comments.
I would not emphasize the word minimalism as much as I would emphasize the word incrementalism. I respect and agree with what Justice Lemons has said, but I think that the incremental approach is a hallmark of a thoughtful court, and so we have to, as I mentioned earlier, we exist within the bounds of law and tradition. And when it comes to interpreting the law, the statutory interpretation, we have to tread carefully, recognizing that we are not to legislate, that our job is simply to apply the various rubrics to determine what did the General Assembly intend to say, and then we apply it to that particular case. When it comes to the law development on the common law side that Justice Lemons was talking about, it should develop incrementally. We are painting on a field where 800 years of judges have come before us. And I don't pretend for an instant that I have the wisdom to just simply go off in an entirely different direction.
Was this a new or difficult experience for you to get used to, given your previous career experience in both the legislative and executive branches?
Sure, absolutely. And I'm not sure that I have reached a level of competence yet, but I really appreciate the fact that my colleagues have such experience and often such patience with having a former legislator on the bench.
Can you say a little bit more about that?
Well, I think that when you look back through the Virginia Supreme Court throughout the 20th century and into the 21st, there have often been former legislators on the bench or former executive officials on the bench. And I believe that we bring a different perspective and an important perspective. But we should also, as a Commonwealth, be quite thankful that on a court of 7, there's not 7 former legislators. Otherwise, you'd have an entirely different judiciary. Most of the individuals who come to the Virginia Supreme Court have been circuit judges in Virginia. 4 out of the 7 of us were. And that is the bedrock of experience. Those of us who came through a different route are able to contribute as well in an important way. But all of our cases, with very few exceptions, have come from the circuit courts, and so I particularly have appreciated the experience and the knowledge that those colleagues have brought to me.
So let's talk a bit about previous career experience. So Justice Powell, you've had a variety of experiences before you took the bench. In-house counsel, executive branch, private practice, service on each of the lower courts. How do you think that's influenced your work here on the court?
Certainly the prior trial court experience has been very helpful if I'm looking at a transcript and I can visualize myself in that courtroom and pretty much tell what chaos was breaking out when objections weren't preserved or statements were made. So I think that experience gives me a deeper appreciation for the trial record and what's going on in the trial court. My experience on the General District Court gives me tremendous empathy and not empathy and a sense of appreciation of the issues that finally wind their way to us and how they're going to impact all of the issues that we will, or the cases, individual cases, that we will never see. The time in the Attorney General's office, tremendous time management skills, time in private practice, sitting at counsel tables, second, third, fourth chair, learning cases from the inside out. And so all of the prior experience, I think, has brought me to this time and place in various and different ways.
Are there things you miss about your life before you took the bench?
I miss the live, in the moment of the trial court. I balance that against the contemplative, being able to think it through of the appellate court. And so there are positives and minuses to both, but I do miss the live in the moment.
Was the sort of contemplative part surprising to you?
No. Okay. I've always, as a trial court judge, I wanted to be able to discuss the case with someone who heard the same case that I heard, as opposed to hearing it through my lens. And so I have that here. And so that aspect of trial court I get here. The live and the being able to decide it on my own without having to worry about what these other guys and gals think.
You miss a little autonomy.
I do miss a little autonomy.
Justice Millett, you talked a little bit about how your experience before you joined the court has influenced your work, but I was wondering if you could talk a little bit more perhaps about your work in private practice. How is that?
I was with a small firm for 6 years, then I was a sole practitioner actually for 6 years, and then a prosecutor for 4 years. So I basically was in court every day, and in all the courts. I was in district court, I was in circuit court, I was in juvenile courts. So I had a pretty broad understanding of the kind of issues that eventually worked their way to circuit court and then eventually worked their way to the appellate court.
Has that affected not only how you perform your role now, but your view of the judiciary or what courts should do?
Certainly. I remember specifically some judges that I was just incredibly impressed with and thought those were the kinds of people that I would like to emulate if I ever could be a judge myself. Now I got to say I never thought I was going to be a judge first of all, and certainly not on the Supreme Court when I first started practicing. It was not in my contemplation. It's just something that developed as my law practice and my career went on.
Was that a difficult decision for you to accept the nomination?
Actually, I became a substitute judge pretty early on. I was 30 years old, and when I first started, I said, well, I think I really like this position. I think I can do this fairly well, and I think that it's something I'd like to pursue.
Justice Goodwyn, can you talk a little bit about your prior experience and how that's influenced your work?
Sure. I guess having been a trial lawyer, I was a litigator and a partner in a law firm, as well as a year as a law school professor. More than anything else, I recall as a trial lawyer being very frustrated when judges didn't explain what they were doing. And when I became a judge, one of the things I wanted to make sure was that anybody who left my courtroom understood exactly why I had done what I had done. And I feel like that transparency makes just a big difference in people's perception of fairness. As I write opinions now, the most important thing I want people to understand, or the most important thing to me about the opinion, is that people can understand why I did what I did and why I see things the way I see them. And at that point in time, they can look, and I don't mind them saying, well, that was wrong. And as a trial court judge, I always wanted to explain to people exactly what I'd done, and if they wanted to appeal it, that's how I'm going to get better, right? If it comes up to the Supreme Court and they told me I made a mistake, I know not to do it next time. Whereas I understand some circuit court judges felt like you never explain why you do what you do, because that's how you get reversed. Why would you be afraid of being reversed? I never understood that. Aren't you more concerned about getting it right? And if you can't articulate why you're doing it, I always felt like you shouldn't do it. You're not ready to decide the case if you can't explain why you're deciding it. And so I guess that's one of the things I took with me when I came to the bench here.
And was it an easy decision for you?
Or the things you miss? Which decision?
To take the bench.
Going on the bench? It was something I decided I wanted to do. You know, I practiced law. I was at a firm I loved. I had a great practice. I enjoyed my partners. But I guess I came to the realization that I wasn't very gratified by what I was doing. And I felt like I did not want that to be my life. I wanted to make a contribution in some way to society. And it dawned on me, and a local legislator asked me about being a judge. And honestly, as a young lawyer, I was like, I don't think I'm going out like that, you know? In my mind, it's kind of like, you know, asking Michael Jordan to be an official. I mean, it's like, well, why would I do that? You know, it just didn't register with me that would be something I would be attracted to do.
All balls and strikes.
Exactly, which I didn't want to do. I wanted to be in the game as a younger person, but once you get a family and you have the demands of law practice upon you, and you think about the other things you want to do in the big picture as far as contributing to society, contributing to the community, and it's hard to fit all of that onto your plate. And I realized that by being a judge, I could do public service as my occupation. It doesn't get a whole lot better than that. And once I sat as a substitute judge, I saw I really liked it. I really liked, you know, not trying to figure out how I can, you know, win the case, but what's the right answer? I'm the guy who gets to sit there and make sure everybody is going to be treated fairly. I was like, it doesn't get much better than that.
So what do you find frustrating about the job? Is there something?
I think what I find frustrating about my present job are the time constraints and trying to do a good job. You know, I guess when I was a circuit court judge, and as a circuit court judge, you have to make calls, I mean, on a regular basis all day long. And I felt like the people in the Supreme Court, you know, they sat there and in my mind they kind of like puffed on pipes and, you know, wore tweed jackets with patches on them and, you know, talked about cases and stuff and got around to eventually writing them. And I got here and I found there are a lot of deadlines and a lot of marks we've got to hit as far as like getting our work done. And so it's a very fast pace. And you've got, in a lot of instances, I would say on a given court week, you know, if we have, it used to be 31, 32 cases, now it's more like in the mid-20s. And there are half dozen of those cases that are really, really hard. They're really, really difficult decisions. You're deciding questions that people have written horn books about. You could spend a month working on one of those cases and still not be sure what the answer is, but you got 6 of them. And you got to do them all in 6 weeks. So, you know, that whole time pressure of wanting to do a good job and getting everything done is sometimes frustrating.
Justice Powell? Oh, I'm sorry.
And I was just going to say, because I always feel this way, and in talking to my colleagues, they feel the same way. There's always more you could have done. There's always another case you could have looked at. There's always something else that, you know, you could think about a little bit longer. You think, maybe I could do a little bit better job if I...
One more draft.
Yeah, exactly. But it's like, you know, it's almost like, I keep drawing all these analogies of television shows, but it's kind of like, what is the Iron Chef or whatever? It's like, time's up. And, you know, you just have to stop at a certain point, and that's what you have to do with your opinions. At some point, I just got to send it to my colleagues and say, I did the best I could do, and listen to what they have to say.
Justice Powell, so you've joined the court relatively recently in comparison to your colleagues. So what do you find are sort of the frustrations or the things that maybe were new to you?
Could not have said it better, the time constraint. I would like to have the opportunity to write the opinion, send it out, sit around the table with them one more time and discuss every page and every line, put it on the shelf, make sure that it's right before we pull the trigger. And what's frustrating is that we don't have the luxury of all of that time. And I don't know if it would be a better product. Perhaps some of my colleagues have had the benefit of all the time they needed and decided the product that they sent out was the best product. But it's the crush of the time and the amount of the work and the need to keep the train moving and the desire
Perfect being the enemy of the good, though, otherwise.
And the
Right.
desire to get it as right as we can get it, and the amount of time that we have to devote to it. So it's a little frustrating.
Yeah. So looking back, let me maybe ask several of you to comment on this, to the first day that you took the bench, and maybe Justice Lemons, I'll start with you. What do you wish you'd known then?
Well, I was asked that question shortly after I came on the Supreme Court with a large audience, and someone said, well, what was your biggest surprise when you got there? And I said, well, I thought we were all going to gather together on Fridays at 5 with perhaps a glass of sherry and discuss Marbury versus Madison.
That didn't happen?
It has not happened, and it is not going to happen for all kinds of reasons. You know, my colleagues talk about the workload. It is extraordinary what we have to deal with. There was a time in Virginia, and I remember as a lawyer, where it would take 2.5 to 3 years to get a case through the Supreme Court. And that was not a good time. And the court had a great deal of introspection back then. I wasn't on the court at that time, but I know they did because I've talked with any number of them, and decided that we need to hand down our opinions as best we can during the court week that follows the court week in which it was argued. Now that makes us one of the fastest turnarounds in America. And like Justice Powell, I think that there are cases that simply cannot be decided properly on that schedule. The idea of turning them around quickly is a good idea. There's just some of them that don't fit that model. So I share the view that many of my colleagues have here, that I wish we had more time, and there's some cases that ought to have more time.
Do you feel as if the process should be changed so that you do have more time in some of these cases?
Well, I think actually that's what's happening now. We respect one another on decisions to carry a case over. And we have been carrying cases over more frequently in the last several years than before. I, for one, think that it hasn't done any damage to the institution. To not have done it would have done damage to our relationships and probably damage to the work product. So I'm not at all concerned about the fact that we have been carrying some of these cases over.
Justice Mims, what do you wish you'd known on the first day you took the bench?
You know, let me rephrase the question slightly. What didn't I know that I quickly learned? And that is the depth of knowledge that each justice has about every case. I had come out of the legislature with 140 members who had to deal with hundreds of issues. And on any issue, most of us had knowledge that was an inch deep. There was always a few legislators who knew more. And ultimately, they have a very fine work product most of the time. Likewise, when I was at the Office of the Attorney General, there were subject matter experts in every single field, and you just had to make sure that you had the right expert working on the right case. Roughly 200 attorneys and handling all of the legal work of the Commonwealth. I got here and found that on every single case, every single justice had a depth of knowledge which at first terrified me and then overwhelmed me, and then gradually I found that I was able to swim in deeper waters, so to speak. But when we publish an opinion, I hope that the litigants and the trial judges and the citizens of the Commonwealth know that it has been as thoroughly vetted and debated and researched and questioned as it's possible to do. And Justice Lemons is right. If we can't do that in a 7-week period, then any one of us can say, let's carry this one over. Let's wait a little bit longer and make sure that we've got it right. And that's quite satisfying but it's also quite exhausting at times.
I can imagine. Justice Millett, what did you wish you had known?
I think how relentless the pressure of the job is, to be honest with you. I was a circuit court judge for a long time, and I thought I worked very hard. But one of the things about being a circuit court judge is when you complete a week trial or 2-week trial, you have to forget about it when you go home that night, because the next day you may have a domestic relations case. Here, you work on these cases, and then you think about them at night, and you think about them all weekend, and you think about them the next day, and you write your opinion, and you still keep thinking about it. And there really doesn't seem to be a time when you don't feel a pressure of getting the case right. I thought when I took the job, I thought, well, I'm going to have a job where I have a little more control of my time, a little more time management, because heck, they only go to court once every 7 weeks. You know, that's a lot of free time in there, and it has not worked out that way.
And there's not as many people you get to talk about it with either.
Now,
right?
the positive side of all that is, it is absolutely the most amazing experience you can have to put together everything you ever learned as a law student, as a trial lawyer, as a trial judge, as an appellate judge, to put it all together and to try to get the very best product you can get. And it is a real feeling of satisfaction, but it's not without the cost of feeling some pressure on you.
Well, that takes me actually to our last question, and Chief Justice, I'll give you the last word on this. We've just been talking a lot about the pressures of time and the frustration, but as Justice Millett just mentioned, there are a lot of wonderful things about the job as well, and a lot of very fulfilling things. And I was wondering if you could talk a little bit about that aspect of the job.
I think the most fulfilling thing for me has been the incredible people with whom I've had the pleasure of sitting. All of these colleagues and all of those others who are not here now that I've had the opportunity to sit with are just incredibly wonderful, extremely intelligent, caring people. You know, we're friends, but just all that we do for each other and the ways in which we challenge each other each and every day to not only be better people, but to be better jurists. It's just an incredible, court is an incredible place to work. It's been a wonderful opportunity, and it's just an incredible job. Justice Millett is right. It is all-consuming. You're never away from it, but the rewards make up for the cost.
Well, I think that's a perfect note on which to end. So thank you so much to all of you for taking the time to have a conversation with us this afternoon. We really enjoyed it, and thank you very much.